The next matter to come before the court is State of Ohio versus Yoakem. Both sides ready to proceed?
Yes, Your Honor.
Yes, sure.
Okay, each one has 15 minutes, and you can be appellant, we reserve the body.
Thank you, Your Honor. Attorney Christina Smith-Bridle, appearing on behalf of David Yoakem in this particular matter. I will reserve 5 minutes for your call on this particular case. Your Honor, this case is a felony case related to 2 errors that I brought to your attention. One of them is the typical, again, sufficiency of the evidence, weight of the evidence argument concerning this case. This case followed, or jury findings followed 3 days of trial. During those 3 days of trial, the jury had to consider a lot of issues, a lot of testimony about how do you make methamphetamine, how do you recognize this, who would have recognized a bag of clear liquid at this scene as methamphetamine. And in this particular case, I suppose I got to give a very, very brief summary. I know that you've all read the briefs of this particular case, but just a real brief outline. My client owned a motorhome that he and his girlfriend were living in. They left that motorhome sometime in August. A couple of weeks later, they were told that there would have been a break-in. They went out to find out what was going on. When they got there, they discovered that it was in a different state than when they had left it previously. The police arrived soon thereafter based on a confidential informant tip from another gentleman. They said, you need to go out there because David Yoakem is out there and he's making methamphetamines. Police go out, they find him and 2 women in the motorhome, which is my client's motorhome. He lived in it, they lived in it up until a couple of weeks before this happened. They also find evidence of a meth hook, but even the experts couldn't say whether this methamphetamine hook was yesterday, was a week ago, was 2 weeks ago, was this morning. They couldn't tell. But they did find a bag, and this is really the only jury finding of guilt that my client wanted to challenge. He wanted to challenge the possession of that bag of clear liquid. It's a felony warrant. He was sentenced to 7 years on felony. Obviously, this is the one that really gets his attention. He goes, well, wait a minute. Jury found me not guilty of making methamphetamine. He was charged with it, found not guilty. Jury found me not guilty of possessing chemicals to finish making that methamphetamine. Even the experts said, you've got to use some chemicals to get this bag of clear liquid from the state it's in to a usable state. That bag of clear liquid, the testimony says, would kill somebody if they tried to use it. That bag would make perhaps 3 to 4 grams, maybe it was 4 to 5, somewhere between 3 and 5 grams of finished product. But because of the way the statute's written, and appellate courts have already addressed this issue, because of the way the statute's written, any methamphetamine found in a liquid, you count the entire volume of the entire liquid, not just what that could create in it. So he was found guilty of possessing over 200 grams of a liquid that, according again to the Medway agent, the expert, you wouldn't recognize unless you're the party or you have made methamphetamine or you're familiar with that process. They also found my client not guilty of possessing some drugs that were found in that particular motorhome as well. So basically, you've got a jury who said he didn't make meth. We don't think there's enough evidence to say he made methamphetamines. We don't think there's enough evidence to say that he got chemicals together to finish this methamphetamine. You had to finish it. You couldn't just use it as is. And we don't think he possessed the drugs that were found in this particular motorhome either. We don't think there's enough evidence on any of that.
Now, those drugs were heroin?
No, this was actually health. It was clozapine, something along that line. So that's what was found there. Now, they did find him guilty of possessing criminal tools and drug paraphernalia. There were some scales found. There was also some tubing found, things like that. So it's interesting that the jury suddenly said, yes, but of all these things that we found here, we think you know exactly what's in this bag. We think you know it's not water. We think you know that this is a liquid containing methamphetamine that you intended to possess.
Well, maybe the jury surmised that from his reaction to the sheriff's deputies showing up and the chief said, oh, this fell into
Yes.
blankets.
Yes, my client's testimony in trial was that he tripped and he fell. He was injured. You can see that in the testimony also, that he did have problems walking. He was injured. And as he was very honest on the stand about this particular point, he had a warrant, he knew it. It wasn't for drugs. It was something related to traffic. I think it was driving under suspension, but I'm not 100% sure. So he knew he had it. In fact, I think it may actually have been a failure to appear for a traffic case, something along that line. So he knows he's got a warrant. He knows the police just arrived.
All three of them had warrants.
I believe they did. I know at least 2 of them did. So that's the big question on the first assignment of error that I raised is there enough evidence to say that he knowingly possessed, beyond a reasonable doubt, that he knowingly possessed this bag, that if he wasn't part of the cook and he wasn't cooking and he wasn't going to finish it, could he have even recognized what it was? And there's no testimony that he could have.
Well, if I'm not mistaken, there was testimony from the neighbor, one of the neighbors, about smelling certain chemicals during the time he was living there.
Correct, John.
And, the jury heard that, also heard that there was some contraband outside of the home, and did not convict him of anything with regard to that. So they must have been paying attention.
Correct, and that's, I think, the most frustrating part of this particular conviction is how can he have nothing to do with methamphetamine cook, but still know what this is?
Well, it's not, from my perspective, nothing to do with it. It's more likely a matter of whether or not the state was able to convince the jury beyond a reasonable doubt. They may have thought and believed that he was involved with it, but just did not find the state's evidence reach the level of proof beyond a reasonable doubt. Whereas, with respect to the evidence in the home, there was constructive possession.
There is constructive possession if he knows what it is, correct? And I guess that's the one fact that I keep coming back to is, did he know?
What happened?
Confidential informant, Mr. Holliday. Mr. Holliday, there was a question about his accuracy, truthfulness, because apparently he'd been dating one of the women and was mad about being shoved out romantically. There was also some evidence that he had been there without Mr. Yoakem in that couple of weeks when Mr. Yoakem testified, and another gentleman testified he'd been living elsewhere. He wasn't living in Florida. So there's a question about, is this confidential informant concerned about a couple of things? One, he's concerned about, I'm trying to remember off the top of my head too, there was something odd about the confidential informant. Now that I think about it, I believe it was that the confidential informant had a sister who had been hooked on methamphetamine theoretically by this individual, and so therefore he had an axe to grind and he was trying to find favor with the prosecutor and with law enforcement by turning somebody else in and getting somebody else in trouble.
But nonetheless, the jury couldn't believe that.
Couldn't believe Mr. Holliday. Correct. They could believe Mr. Holliday that he is aware that my client is out there cooking. The evidence, though, says that cook didn't happen that morning. It could happen yesterday. It could have happened a week ago. So the confidential informant got that part wrong, that the cook happened that morning. There's nothing there showing that there was something right that morning when my client was there that was happening, because you're involving something that's got chemical reactions, it's got heat involved. And they didn't find anything saying, yeah, they just didn't cook this morning. So there's a question, and correct, the jury could have found that, and that's the bigger issue as well. We've got to defer to the findings of fact made by the jury.
Well, was there evidence that whatever had happened outside was recent? I'm not sure if it was like within a day, but was there some testimony that there was recent activity?
I don't believe, I'm trying to remember off the top of my head, Your Honor, because this was several hundred pages of transcript. I don't recall there specifically being somebody saying, yes, this must have happened within the last 24 hours. My recollection was that the testimony was that this could have happened at almost any time, and there was evidence of prior cooks, and it's possible it could have been 2 weeks ago, possible it could have been yesterday, but we don't know.
What about the sentencing issue?
Yes, the sentencing issue, Your Honor. The law is clear that a judge is not permitted to sentence a defendant based on the judge's belief that they should have been found guilty of something additional. In this particular case, the judge does say something along the lines, and I'm going to flip over to make sure I get the language correct. The judge says that, let's see, considered to a lesser extent, I think the court has the right to take this into account. You testified on Friday to the trial that you've never made meth in your life, and the court believes that's a law of the first degree. That's not true. It's a lie. There's two things that you could read from his statement. Judge Weiss could have meth. I think you're lying that you made meth on this occasion. The jury found him not guilty of making meth on this occasion. The judge could also mean, I think you're lying in that you have made meth at some point in time in your life, even though you don't have a conviction at this point in time for meth. So the question is, did the judge mean, I'm going to penalize you in part based on the fact I think you lie on the stand, which is permissible? Or is the judge penalizing him based on the fact that the judge believes that he should have been found guilty of making meth? That's the distinction, and because it's hard to tell, and we err on the side of caution in favor of the defendant, on this particular issue, I asked the court to consider sending this back for resentencing so the judge can just be very clear about what did he mean.
Well, what's our standard of review?
Standard of review on
Is
this.
this a Kalish issue?
I believe it is a Kalish issue, yes, sir.
So it has to be
Clear and convincing evidence standard. Correct, Your Honor.
And counsel, you're into the comment about mistaken.
Very good, thank you, Your Honor.
May it please the court, Ms. Rydell, Nathan Shaker on behalf of the appellee in the state of Ohio. Getting to the sentencing issue that was last addressed by Ms. Rydell, I think it's of the utmost importance that we consider the context of the sentencing judge's statement. On page 16 of the transcript, he goes through a bit of a speech about the defendant's prior record, his age, saying, you're not a young man anymore, you continue to commit these kind of offenses, addressing the ability of Mr. Yoakem to be rehabilitated. And after those statements, he makes the statement about the Whopper of the first degree. I think in that context, this was clearly permissible. Also, the other contextual issue is that this was a sentencing on two cases. The judge was talking about two cases here. Both this case and 14-0024, which was a case where Mr. Yoakem had pled guilty to manufacturing methamphetamine. So at that point, Mr. Yoakem actually had pled guilty to the charge, and that was juxtaposed with what the judge heard earlier. So it was clearly a lie about what he had said on the stand. And regarding
The two sentences, the two cases being sentenced at the same time, is that in the record?
it is in the record. I
You
mean,
didn't have to read it.
I don't believe so. The record, I think, the record initially starts out and says that we're here on sentencing. He entered, the trial happened Friday before, and he was being sentenced on both cases. State versus Odell, the Ohio Supreme Court found that when a sentencing judge is the same judge who presided over defendant's trial, the defendant's act of lying under oath is a factor that can be considered. That's contrary, that's following the U.S. Supreme Court's decision in Grayson, and that undermines the authority cited by Mr. Yoakem, the Jones case and the Patterson case out of the 10th District, which relied on Jeffers, which was a 1st District case.
And all this is in the record.
Yes, that's all in the brief. And that Jones and Patterson relied on Jeffers, which was decided a couple days before the U.S.
So he
Supreme
pled guilty to the manufacturing prior to the jury trial.
He pled guilty to the manufacturing in between the jury trial and the sentencing on both cases.
So he had not pled guilty when he indicated on the stand that he did not manufacture.
No, but the judge was, I think, to shed light on what the judge was saying at that point in time, he had already pled guilty, I think, earlier that day to that charge, and the judge was addressing all that in sentencing. So, I mean, that statement is directed at both cases, and I think the court was clearly able to consider that in passing sentence. Regarding the manifest weight of the evidence and the issue of whether the jury could have concluded that Mr. Yoakem knowingly, constructively possessed this solution mixture of 223 grams of liquid and methamphetamine. The jury heard both the testimony of Mr. Cecil and the confidential informant that Mr. Yoakem was a drug dealer. They had bought methamphetamine from him, that he had cooked methamphetamine. I believe Mr. Cecil stated on August 22nd he was at the motorhome and methamphetamine was cooked. That surely weighed in on the jury's decision, as well as just the general amount of paraphernalia and other items, that this is a person who's involved in the drug trade, the culture of using drugs, therefore. Correct. And
So they obviously didn't believe the confidential informant.
well, I think, again, we could have got to reasonable doubt that what essentially the defense was that people may have came and gone and cooked at another time. So Mr. Cecil could have cooked, somebody else could have cooked. It was a rational decision by the jury to acquit him of those charges. In terms of the possession, he was there, he was hiding, he was in the mobile home with this liquid, and there's plenty of reasons why he would have known what this liquid was for the evidence to support the jury's verdict. Unless the court has any further questions, the state would rest on the merits of this brief.
I think so, thank you.
Thank you.
You've done 3 minutes.
Very good, thank you. Your Honor, I did want to point out, I was looking through my notes on the transcript in this particular case, and as to Mr. Holliday, he was a confidential informant who gave that information and said, hey, David Yoakem's out there cooking this morning. There's some additional information in the transcript. For example, on page 105 of the transcript, Holliday admits that he hadn't seen David Yoakem out there since the 10th of August, and this allegedly happened on the 23rd.
He had not.
Correct. He had not seen him out there since then. There's also testimony that Holliday was he was selling to another gentleman in that time, and he was selling methamphetamines as well. So that also brings his testimony a bit into question. If he's actually, somebody goes to the stand and says, oh yeah, that confidential informant, he sold to me in August. So there's a question about whether or not this is about him trying to get himself out of trouble and handing them somebody else.
With the sentencing issue, what does it really matter whether we believe him or he didn't believe him if he already pled to cooking methamphetamine? Because obviously he can consider that.
Correct, Your Honor. I think the answer to that, Your Honor, is simply that we want to make sure that the judge doesn't take into account something he's not supposed to. And like I had mentioned before, the judge is perfectly welcome to take into account the things that the defendant lied on the stand. And if I remember correctly, the defendant actually admitted at one point on the stand, hey, I just lied about that, and my story was wrong, and now I'm going to correct it. And so that is...
What was precisely the lie?
I actually don't remember, Your Honor. I wish I could... Yeah, I wish I could remember what he lied about, but it wasn't in relation to did I get methamphetamine or not. It was something tangential. Whether somebody was in the property one day or not, something along that line that he admitted he lied about. And then...
But for the judge to say that you're suggesting that you never made meth, and that's a big lie. That's what the trial court was referring to, correct?
If that is what the trial court is referring to, then yes, that is permissible. If instead the trial court is saying, I think you lied about when you made meth that day, that's the differentiation as to whether there's an issue on the sentence in this case. The only other thing I want to point out, Your Honor, is that the jury again found that he did not constructively possess the pills that were in They were out in the open, he could have seen them just as clearly, he could have seen this bag of liquid. And so that leaves us with the question of, why is this particular bag of liquid sitting out in the open different? What additional evidence do we have that he saw this bag and knew what it was, as opposed to those pills? Because we found him not guilty of constructively possessing the pills, but guilty of constructively possessing, at least constructively possessing that bag of liquid. Unless Your Honor has any other questions? I just ask Your Honor to consider the arguments in this case and find the time.
Thank you very much. Again, we will take that under advisement, issue a written opinion to both sides.